Hi, my name is Chris Duren, and I'm an attorney in Wisconsin who's had his own law practice for the last 18 years. Today I'm going to discuss a legal topic with you. Please keep in mind that I'm just going to give you a very brief oversight of the legal topic. What I'm going to talk about today is not legal advice and does not create an attorney-client relationship. It is my strong advice that if you do have a legal issue or questions, that you consult directly with an attorney. Hi, the topic I'm going to be talking about today is filing a small claims case in Wisconsin. Just so you know, every county has a little different procedure. The procedure I'm going to talk about today is Dane County. But if you are filing in another county, my advice is to consult your local court, small claims court procedures. I guess the first question is, when can you file a small claims case? And I guess I'm going to talk about just when you are seeking money damages. In Wisconsin, you can file a small claims case if your money damages are less than $10,000. If you're seeking however, if you are seeking money damages for either personal injury or for a tort injury, that limit is actually $5,000 or less. So if you're seeking money damages over $10,000, it's not a small claims case. Or if you're seeking tort or personal injury damages for more than $5,000, then it's not a small claims case. The procedure starts by filling out a summons and complaint. Every county has a standard form that you can use, and usually if you go to the website, you can download that form and print that off. If you fill it out, you file it with the clerk of court's office, you pay the filing fee. As of the date of this video, February of 2016, the filing fee is $94.50. Once you file that lawsuit, the original is filed with the court. You need to have 2 copies to serve, and then that lawsuit has to be served personally on the defendant. And the best way to do it is either to hire a process server, a private process server, or have the local sheriff for your county serve the lawsuit, assuming that the defendant lives in your county. After the lawsuit is served on the small claims, there's what's called a return date, and that's the date by which the defendant has to either answer the lawsuit. If the defendant does not answer the lawsuit by the return date, then you get a default judgment. And the court will enter that. If the defendant does proceed to file an answer with the court and provide you a copy of that, then the court will schedule the small claims hearing in front of the court commissioner. And normally, in my experience, the court commissioners schedule this for a 1 to 2 hour period of time, and that's where you go into the courtroom. It's usually a smaller courtroom. The court commissioner is up on the bench. The plaintiff and defendant each have their tables they sit at, and the plaintiff and defendant each provide their evidence in the case, and then the court commissioner issues a ruling. My experience in doing small claims cases is that court commissioners love documentation. So if you should bring in whatever documentation you have to support your case, but make sure you bring in a copy for the court, a copy for yourself, and a copy for the other side. But make sure you have all your documentation organized and ready to go for your hearing. After the hearing, the court commissioner will either give a ruling to you that day, or they will sometimes issue a written ruling, and then you would receive that in the mail from the court. Small claims court has one unique procedure in that if either side doesn't like the result of the ruling from the court, either side can request what's called a de novo hearing. If the ruling was issued by an oral ruling, then you have 10 days from the date of that oral ruling to request a de novo hearing. It means ask for a brand new hearing in front of the circuit court judge. If it's a written ruling, then you have 15 days from the date of the written ruling to request that same de novo hearing. And when you request that de novo hearing, you're going to get a brand new hearing in front of a new judge. It'd be a circuit court judge. And you're basically starting all over again. Each side gets, what I like to say, get 2 kicks at the cat. And you're going to have the circuit court judge is going to schedule you for your second court trial in this case. Now, if after the ruling by the circuit court, either side doesn't file a de novo, then your case is done and there's no second hearing. But if either side's unhappy with it, then either side can request a de novo hearing and have a new hearing in front of the circuit court judge. At the court commissioner level, the rules of evidence are a little more informal. Sometimes the court does allow hearsay evidence in, and it's not as a formal it's not as a formal proceeding as it is at circuit court. But at the circuit court level, it is definitely a more formal hearing. My experience is that the rules of evidence do apply, and the circuit court judge do enforce them. So it is important to be aware of the rules of evidence when you do go in front of the circuit court judge. The small claim court procedure is set up that you can do it without an attorney, but but my advice is always to either have an attorney represent you or to at least consult with an attorney, and to help them at least have them help you prepare for your small claims hearing, so you present the best case that you can. But after that second hearing, if one is needed, the circuit court judge will issue a ruling. Again, it could be oral or written, but that will be the final ruling at the trial court level. There's no more de novo requests after that. And if the plaintiff is able to obtain a judgment at that time, then the plaintiff will have that judgment, and then the plaintiff can proceed to collect that judgment against the defendant.